show. It's good to have you, and greetings.
I greet you, Kalaga. Good evening, and I greet everybody who's listening to us from Port Harcourt and everywhere.
All right. So it's no longer breaking news. The Supreme Court gave a verdict on local government autonomy today. We are yet to see the entire, the what do you call it now, the certified copy of the judgment. What has been reported says that it has given financial autonomy to local government and that states cannot in any way help spend or hold or do anything to the finances of local governments. As a matter of fact, one of the news platforms reported that the court asked that the monies be sent directly to the local government. Also, it made mention of the fact that local government chairman cannot be removed just like that by state governments, and some people have also further interpreted that to mean that it must be democratically elected government and not a caretaker system. So I know the last time you and I had a conversation, we had a conversation related to the local government, but welcome. What's your take on this judgment first of all? Let's start from there.
Yeah, it's a judgment that Democrats in Nigeria welcome with open hands. It's a judgment that has clearly defined the provisions of Section 162, subsection 6, and then 7 of the Constitution. You remember Section 160 of the Constitution that talks about distribution pool account, about public revenue, and specifically subsection 6 of that section, that created this state local government joint account that allows money to be paid into such account, and then the state shall now distribute the money to the local government, also taking into cognizance the principles of derivation. But that section over time has been abused by the state government, including Section 9 that talks about judicial autonomy, subsection 9, Section 162 also that talks about judicial autonomy. State governors have consistently abused that section. So what the Supreme Court simply did was to interpret the provisions of that Section 162 to mean that local government shall earn their money directly, and that the state government, even if this money are paid into a joint account, that the money starting to the credit of the local government shall go directly to the local government, and the ones to the state shall go directly to the state. And the state has no powers to, the state has no power to, manage the funds, standing to the credit of the local government, even though Section 7 of the same Constitution gives the state House of Assembly powers to make laws for the administration, control, finance, and finance of the local government.
Okay.
So that's basically what that section, what the Supreme Court interpretation had done. And then a lot of people also had said that the section also, the judgment also, it also be reported, and the judgment also had stated that the funds should not be paid or credited to states or local government that are not democratically elected. So like you said, we wait to read the certified true copies of the judgment, and then when we read that judgment, then we can now begin to interpret what that the will not be able to speak to the extent and far-reaching implication of the judgment. But for now, what we can gather for the public really is the fact that the judgment, speaks on this main area of local government autonomy, and which for me is a welcome development. Like I said before, it is encouraging, because considering the fact that we consistently had advocated that we should have, a properly structured federal government and not what we are practicing now. And local government being government at the grassroots, which is governance at the grassroots level. And if we say all government is local, then a situation where finances comes directly to the local government, a situation where elections at the local government level is credible, even more credible than the national election, and then we would say gradually that we are moving towards a more developed, structure called Nigeria, not the current one that we operate, where the entire country is like a local government on its own, where Mr. President is the local government chairman, who distributes everything. For me, what's the business of a federal government, for example, with marriages? What's the business of federal government with licensing of vehicles, trucks? What's the business of federal government with unity schools? The federal government should have more to tinker with. And that's why the federal government controls about 52% of the revenue, while the state and local government barely also manage about 40-something percent of the revenue, while 4% is for ecological funds. So it's a step in the right direction. It's good for our democracy.
All right, now, Barrister Oshoma, you mentioned Jack, and you said the Supreme Court has interpreted it to mean that the money should go. But a lot of people, even me, up until now, understood the joint allocation account to mean that the monies will be sent to the state government, and then the state government will then distribute, in River State's case, to the 23 local government areas. I'm still a little bit confused about that. Can you expatiate or explain further what the Supreme Court said about Jack, in your opinion, looking at the judgment?
Let me please permit me to read that section to you,
okay.
So for purpose of clarity.
So that's section 16.
Section 162. Subsection 6.
Okay.
Section 162, subsection 6. You say each state shall maintain special account to be called state joint local government account, into which shall be paid all allocation to the local government council of the state from the federation account and from the state and from the government of the state. Subsection 7 says each state shall pay to local government council in its area of jurisdiction such proportion of its total revenue on such terms and in such manner as may be prescribed by the National Assembly.
Okay.
Subsection 8 says the amount standing to the credit of local government council of state shall be distributed among the local government council of that state on each terms and in such manner as may be prescribed by the State House of Assembly. Do you get my point now?
Yes, I understand.
So you need to read the three sections together. It's called a state joint local government account for all the local governments. And each state shall pay to local government council in its area of jurisdiction such proportion of its total revenue on such terms and in such manner as prescribed by the National Assembly. That's revenue from the federal government. So the revenue from the state government shall be prescribed by the State House of Assembly. So all of these funds ordinarily meant for all the local government in the states, not for both states and local government.
Okay, so that means the account is even for the local government, not necessarily to join.
Yes.
Oh my.
No, the account is for the local government.
Interesting.
Because Section 7 empowers the state to make laws for the administration and finance of local government, this account is created for the management of the funds of the local government, where the federal government funds shall be paid into, the state government fund also will be paid into, and then these funds will be handed over to their various local governments. But what the state has done consistently is to collect this revenue meant for the state local government, then they dip their hand in it, collect a portion of it, despite also, the state funds are paid directly to the state.
Yeah.
While the local government funds for that state are paid in the state joint account for local government. So state fund, the funds meant for the state does not even go into that account. It is government fund goes into that account. But what government do? If 100 million goes into that account, but local government, joint local government, what they do, the state will go and pick out 40 million, are taking their own. It's like armed robbery. It's like banditry. So they go there, the money that is not there, they go and take and add to what they have taken. And then now tell local government, okay, manage this 50 that is available. You take this, you take that. And then now says, oh, don't worry. That is why state governors will want to always determine who becomes local government chairman. And in some cases, when they can't even do election, or when they can't determine by election, they impose. They say caretaker, the mayor, liaison officer, all kinds of names. So that's what section 6, 7, and 8. So what the Supreme Court had done now is to interpret that section by removing the veil, whatever ambiguity that people thought, existed there, to say no, there's no ambiguity. It is as clear. You are not entitled to local government fund. The local government fund shall go directly to the local government and not for the consumption of the state government. So that is what it means.
I do have a commercial in 3 minutes. I'm going to quickly rush this question. So now that we know, about 21 states are running caretaker systems at the local government level. What happens? No. I got an updated version that said it's about 21. So if it's 18 or 21, whichever one, the question then is, what happens to these states? For instance, in Rivers State, the local government election...
The local government funds cannot be released to a local government that do not have democratically elected government. That's what it means.
Okay.
That's what it means, because with the court, because part of the question submitted for the adjudication or determination of the court is Section 7, the application of Section 7 also. If, by virtue of Section 7, a governor can unilaterally sack a local government, or a local government whose tenure has expired, whether there should be room for lacuna. Since there is no room for lacuna in the state and federal government, you can't say you can't conduct local government election and then you allow caretaker committee. If we say we can't conduct state election and you allow caretaker committee as state governors, don't you think Nigeria will be on fire by today? So the section did not provide or give room for a situation where there's nowhere in the entire gamut of the Constitution where caretaker committees or in any name whatsoever described is mentioned, at the local government level. So what it means by this judgment is that any amount standing to credit of local government shall not be paid to a local government that does not have a democratically elected local government, because the Constitution cannot give with one hand and take with another. The court can't give with one hand and take with another. I can't say, okay, pay the money directly to them, and then you allow the governors to maintain caretaker committee. What it means is that if the governors still have caretaker committee, if you pay the money directly to them, they will just use their caretaker committee to remit the money back to the state account.
All right. We do a commercial break, so I would ask you to please hold on, because I have a question I want to throw at you now. You have talked about how the government will not pay states that have caretaker systems, but in certain states, for instance, Rivers State, the local government chairman have had their tenure expired, and elections are not up until October 5. Do stay tuned. We'll be right back.
Nigeria Info. We'll be right back.
Let us quickly take a look at the headline news. Supreme Court ruling on financial autonomy for local government stirs reaction. Serap calls on governors to account for local government funds or face legal action. Meeting between President and organized labor ends without pronouncement. On the foreign scene, Kenyan president dismisses almost his entire cabinet. Details in the 6 p.m. bulletin. To reach the news team, send an SMS or WhatsApp to 0808 721 7215. I am Kalada Rubatibo. To stay tuned.
This is Hard Facts.
All right, 29 minutes to the top of the hour. Yes, you're listening to Hard Facts at 92.3 Nigeria Info. I am Kala Dakorubatiba. Remember, you could follow me. I would love it if you do. Social media, DKalada, THEKALADA. But we're live on Facebook right now, Nigeria Info PH. On YouTube, Nigeria Info PH, we're live as well. And we're active on X, Nigeria Info PH. And we're looking at the Supreme Court verdict as it relates to the financial, not just financial, local government autonomy, basically. And I'm looking at my copy of the Constitution, section 162, subsection 1 talks about the Federation maintaining a special account called the Federation Account. Subsection 2 talks about the creation of the Revenue Mobilization, Allocation and Fiscal Commission that will, determine how the monies would be divided. Section 3 talks about the monies being distributed among the federal and state government and the local government. Subsection 4, I beg your pardon, I keep saying section, all of these are subsections. Subsection 4 talks about any amount standing to the credit of the states in the federation account shall be distributed among the state in such terms and in such manner as may be prescribed by the National Assembly. Section 5, the amount standing to the credit of local government councils in the federation account shall also be allocated to the states for the benefit of their local government council on such terms and in such manner as may be prescribed by the National Assembly. And Section 6 says each state shall maintain special account to be called State Joint Local Government Account, into which shall be paid all allocations to the local government councils of the state from the federation account and from the government of the state. Each state, subsection 7, shall pay to local government councils in its area of jurisdiction such proportion of its total revenue on such terms and in such manner as may be prescribed by the National Assembly. Subsection 8, the amount standing to the credit of local government council of state shall be distributed among the local government councils of that state on such terms and in such manner as may be prescribed by the House of the State. Remember, with me having this conversation is a Lagos-based lawyer, a socio-political commentator, Liborous Oshoma. Welcome, Esquire. It's good to have you.
Yeah, my pleasure, always, Kalada.
All right, so before that very long commercial break, you just said that the federal government would not release money from the federation account to states where they are running caretaker systems at the local government level. But let's look at states that are unique, like Rivers State, where there is the expiration of local government chairman's term. Of course, there is the appeal ruling. Even before the ruling, some lawyers had argued that it does not make sense to extend people who swore an oath for a particular amount of time, their time in office. So then, what then can we do? Because the election for local government has been stated October the 5th. So, a unique system. What then happens in this situation?
There's nothing unique about River State system.
Okay.
There's nothing unique. If we allow that state is unique, it that means every state whose tenure has expired, where local government tenure has expired, is unique also. The states knew that the tenure was going to expire as at when it expired. The government knew that the election was going to expire, and it expired, and so they waited. They didn't come. They waited. They were waiting to swear in caretaker committee. I am one of those lawyers that have argued that the State House of Assembly has no power under any guise whatsoever to extend the tenure of democratically elected local government chairman.
Okay.
What the State House of Assembly River State surreptitiously did was to smuggle in section 135. Please, just thank God you have a constitution.
Yes,
there.
I do.
Go to section 135, subsection 3. Section 135, subsection 3 of the Constitution. You see there, you see tenure of the office of the president.
I don't know if my constitution is the old edition, but I'm seeing
both old one or new one. There's an alteration added. Subsection 3 has been there, but subsection 2 was added.
Okay.
If you look at subsection 3, it says if the federation is at war,
yes, true,
in which the territory of Nigeria is physically involved, and the president considers that it is not practicable to hold election, the National Assembly may by resolution extend the period of 4 years mentioned in subsection 2 of this section from time to time, but no such extension shall exceed a period of 6 months at any one time. That is the section that your State House of Assembly in Rivers State lifted and added to Administration of Local Government Law number 2 in Rivers. So that section, what they did was went to section 135, copied it and added it to Local Government Administration Law number 2 in Rivers State, giving the local government, the House of Assembly power to extend the tenure of local government. But if you look at this section, it says when the nation is at war and it is impracticable to hold election. Is Rivers State at war that makes it impracticable to hold local government elections? The answer is no.
Interesting.
There is no war in Rivers State. And even if that be the case, if there is a war, it is the governor that has the power to address the National Assembly, the State House of Assembly, and ask for extension. Assuming that we are looking at this section now, even though no governor has such powers, there is no provision in the law that donates such powers to the governor. It's only the president. So that act of the State House of Assembly, ab initio from day one, is void. It is illegal. It is unconstitutional. So the governor, knowing that it is unconstitutional, you still waited. Even though you waited, you didn't conduct local government election, but you know you were going to sack them anyway because I won't say sack. You know their tenure had expired by fruition of time. You now waited, and then you now impose caretaker committee. You say, "Oh, we are preparing for election." For me, there is no special case there. If we give Rivers State a special case, it means every other state whose tenure had expired, whose local government tenure had expired, will play the special case also that they couldn't conduct elections, so they put in place caretaker.
All right,
committee.
now let's quickly.
What this interpretation had done now is to hasten the process where state governors will hurriedly conduct local government election, even though at the end of the day it is their people that will still win. But let us give a semblance of democracy at the local government level, for crying out loud.
Okay, I was going to borrow, something from the Electoral Act 2022, where, it says something about if there is violence in a place, then it can be said that election did not hold. Can that also be a reason why elections have not been conducted in Rivers and Minio? They say,
if election is conducted, and in the process of the conduct, there is violence to disrupt the process. It's different from where it is impracticable to conduct election. These are two different scenarios.
Interesting.
The election did not even start at all to talk of, there was violence too. And it is the people that even went ahead to say, look, your tenure had expired, leave office. So these same people would have come out on the same day to cast their vote to say, we want these people out of office.
True.
If you have given them the opportunity.
True.
So the idea of waiting and now hiding under a tenure elongation, which we know is clearly unconstitutional, cannot avail Rivers State, or any other state for that matter. If you avails Rivers State, what other states would do? The mischief that the Supreme Court has cured today will be opening up a new, opportunity for mischievous governors to use it. What stops them from going to create, for instigating the House of Assembly to extend tenure? And then somebody goes to court and says, it's unconstitutional, And then in answer, because of that case, and so we didn't really know what to do. And so we put a caretaker committee. And then, so what the mischief that all of this is trying to cure is to avoid a situation where people who are democratically elected will now begin to run local government with non-democratic people. Imagine the adverse you played just now. A caretaker committee chairman appointing 20-something aides at the local government level. It's an aberration. That's an abuse to democracy. Imagine a situation where you now impose on a state a caretaker governor and assume that it is impracticable to conduct election. How do you think that will sound? So I think it is proper. Let all the states, even though we know that our state electoral bodies are truly not independent, they know how they impose their people, but let it be a semblance. I don't want a situation where an independent, truly independent body will be conducting local elections at the local government level. So this idea of one party sweeping the pool, and another one party, once a party rules the state, they sweep the pool at the local government election. We'll avoid it. As much as we complain about national election conducted by INEC, why don't we use the same strength, energy, and vigor to complain about election conducted by our state electoral body and our state emperors masquerading as governors? Why don't we complain also? We just say it is their thing and we just wish it away. But at the national election, we all complain, we all come out, we call names, but we don't use that same energy for government that is closest to us.
Okay.
All of this is because we think the federal government is a behemoth and it takes more.
I've got one final question for you because my time is up. I've got a commercial yet again. And that is now, in government, they say there's no vacuum. For instance, if the president dies, the vice takes over. If the vice is not available, the Senate president takes. So there is that, filling the vacuum. What then happens in Rivers State? CTC illegal, extension illegal. Then who takes over government at it? Because election is October 5.
What happened? What should have happened? Canada, you have a constitution there. Please, quick.
No. You said what should?
Section 7. Wait now. Wait. You have a constitution there. Read section 7 of the constitution quickly. You will see a system of local government by democratically elected local government council is under this constitution guaranteed. When something is guaranteed, it is compulsion. It is come rain, come shine. It is guaranteed. It didn't say that you shall. When just the same way we do election at the state level, when you know that the state tenure is about to expire, the state governor's tenure is about to expire, elections are prepared for and conducted. Just like Edo, we know that the tenure will expire in November. By August, they'll conduct election. So that after election, you prepare for handing over. So when you refuse to conduct election, all that should have happened, what the governor had done before was hand over to the officials at the local government level. You have whatever the name they call them, secretaries at that level.
All right, I've got to go. I'm sorry.
Ought not to last more than a very certain time. But